Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates. So, we received an interesting inquiry on our YouTube channel. This has to do with having sex with his wife, being drunk, and was arrested for rape. Rape attorney, Morgan Hill. Criminal attorney, Morgan Hill. Accused of rape, Morgan Hill. Let's see. I had sex with my partner, and suddenly the police arrived and I was arrested for raping my partner. Now, my wife wants to eliminate the charges because she says I was drunk and was not aware of what I was doing. Well, first of all, let's talk about rape. Rape is having sex with another without consent. This is a violation of Penal Code Section 261 here in the state of California, which carries up to 8 years state prison, plus having to register as a sex offender for life. Now, this part's really important. Involuntary intoxication is not a defense. Involuntary intoxication is not a defense. What that means is I don't care how drunk you got. I don't care how high you got. If you got there on your own, it's not a defense. You can't tell the court, well, yeah, I raped and I killed a bunch of people, but I was drunk, I was high, I didn't know what I was doing. No. It's not a defense. Involuntary intoxication is not a defense. Is it a mitigating factor? Yes. It is a mitigating factor to get less punishment. Yes. But it's not a defense to the crime. Now, the other issue is, it says right here, that your wife wants to eliminate the charges. She can't do that. Only the DA can drop charges. The DA is the only one who decides to file charges, against whom, and what charges to file. The victim has no say in the matter whatsoever. The DA, if the victim goes up to the DA and says, yeah, my husband raped me, but he didn't know what he was doing because he was super drunk, please don't charge him. The DA is going to be like, no. If you didn't do it at all, that's one thing. If you made a false report, that's one thing. But if you committed the crime, I don't care if you don't want us to proceed, we're going to proceed. The victim doesn't have power. The victim, remember, when somebody commits a crime, it's against society as a whole. The victim is essentially a witness in a sense. But yeah, the victim does not have the ability to dismiss charges. Only the DA can do this. So it's very important to talk to an attorney immediately because you don't want to say anything incriminatory. You don't want to be telling the court, oh yeah, I was super drunk, that's why I did it. No, that's an incriminatory statement. You might want to keep that to yourself. Regardless, if you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation, call us here in the San Francisco Bay Area, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who's being accused of extortion.